Assalamu alaikum. Um, Under the Section 17, the Contract Act 1872 is discussed about the fraud and what is actually fraud. Because if you obtain any consent via fraud, then such consent it cannot be called as a free consent. So, what are the effects? What is actually fraud, and where the contract will go if the fraud exists within a contract? So, I'll tell you about in this video under the section 17. So first of all, under the section 17, it has been discussed that the fraud means and includes any of the following acts committed. Okay, these are the five acts which can be called as a fraud. The first one is acts committed by a party to a contract or with his connivance. It means party itself perform a fraud or with his connivance means it is actually a willingness to allow or be secretly involved in an immoral or illegal act or by his agent with intent to deceive another party to it or his agent or to induce to enter into a contract. So in a nutshell, if any person by himself or by the other person um, has an intention uh, perform an act to bound any other person into the contract and the intention is actually to deceive that party is called a fraud. Okay, so under the section 17, if any time it will occur, then we can call it as a fraud. What are the examples under the section 17? Because definition itself is incomplete because due to its further explanation. The first one is the active concealment. Okay, what is actually active concealment? The active concealment of a fact by one having knowledge or belief of the fact, such as where steps are taken by a seller concealing some material facts so that the buyer, even after a reasonable examination, cannot trace a defect. It will amount to fraud. Okay, like Mr. A is a seller and Mr. B is a buyer, and Mr. B is willing to buy a certain amount of goods from Mr. A, but Mr. A knows that the material has been defected and it will be expired within a week. Okay, let's suppose the goods are a medicine. Okay, so he knows that it will be expired within a week, but if you are a medical representative, you cannot trace the expiry of that medicine even after a reasonable examination as well. It is very and very tricky. It will all go to the laboratory test. And so if normally if you buy a medicine from anyone and if there's an expiry has been written on it, you always trust on it. But if Mr. A is selling such medicines to Mr. B, which has an expiry after a week, and it has been written on that medicine that it will be expired after 2 years, then it is an active concealment because it is under the knowledge of Mr. A, the seller. So it is also concluded as a fraud. The second one is the empty promise. A promise made without any intention of performing it constitutes a fraud. Like, let's suppose in this case, medicines are um, legally valid because they will be expired after 2 years. But Mr. A, when deliver all medicines to Mr. B, Mr. B is not paying the sum of money against the delivery of medicine. It can be called as a fraud because Mr. A, when go to the court and file a case against them, then he may call it as a fraud that he has done a fraud with me because he has signed a contract that he will pay that sum of money against the delivery of such medicines. But now he is not paying. He has done a fraud with me. He lied with me. So please look after this case. The third one is a declared act. Any such act or omission as a law specifically declares to be fraudulent. Okay, there is a list of declared act. Okay, anyone performs such act, then it can be eventually called as a fraudulent, or any other act fitted to deceive. Like you have done any act which actually deceive the other party can be called as a fraud. So these are the four examples of the fraud under the Contract Act 1872. The first one is the active concealment. The second one is empty promise with there is no intention to perform the promise. And the last one are the declared act and a fitted act. Declared act, declared already declared by the court that these act are the fraudulent act, and fitted act actually you have done any act which may be considered as a fraud. Now, what will be the effects of fraud? So, under the section 19, the effect of fraud is below. The contract become voidable at the option of the party whose consent was so caused. It is still a voidable contract for the innocent party whose consent was so caused. So, that party may rescind the contract or may continue the contract. But the party whose consent was so caused may insist on performance of the contract. Of course, if they affirm the contract, if they not choose the term void for this contract, then they may insist the performance of the contract to the other party. The party whose consent was so caused is entitled to claim damages. Okay, so but it is in the case of void contract. If again, the second and third point I would like to explain further. Uh, as in the first point, it has been written that it is avoidable at the option of innocent party. If they affirm the contract, okay, if they continue the contract, that the second point will be valid. That after giving the performance, that party may insist the performance to the other party. The third one is okay. It is also after the knowing the fact that they have done a fraud. The third one is the party whose concern was so called entitled to claim damages if they have delivered, if they received the goods from Mr. A, who has done a fraud, and after coming to the knowledge the fact that the fraud has been done by the Mr. A, and so it is avoidable contract for Mr. B, and when Mr. B choose the void contract option, then that innocent party may claim damages from Mr. A. Now, the most important point, silence as to fraud. So, mere silence effect likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that parties stand in fiduciary relationship or where the silence itself is equivalent to speech. Okay, so we have already knew that uh, if someone offer the other party, another party keep himself silence, then it can be constituted as the acceptance. Okay, so here it is written that mere silence as to fact likely to affect the willingness of a person to enter into a contract is not a fraud. But there are some circumstances where the silence itself is equivalent to speech. Okay, and unless the circumstances of the case are such that parties stands in fiduciary relationship or where silence itself is equivalent to speech. So the contract act cannot called not cannot the contract act actually has not declared the silence as a fraud. Okay, because silence itself equivalent to the speech if there is a fiduciary relationship, and what it is equivalent to speech that they are ready to bind himself into the contract. But if it actually we've already discussed about the silence, that due to silence if they have not received any message from the offeree regarding acceptance and rejection, then the other party always presume that it is an acceptance. So under section 17 it is also concluded that it is equivalent to speech. It means it is the affirmation of the other party, and there is a fiduciary relationship between these parties, so it can be assumed that it is a speech, that there is an acceptance. But if they will not perform after the silence, then it cannot be called as a fraud. Okay, it will be something different. We have already discussed that due to silence, if any party keep himself silent and does not perform and does not accept the offer as well, then the offer have a right to sue him or her to the court, because they have not given the acceptance expressly. So this is all about the fraud. Thank you so much.